within the legislative party, which alone is a dissent on which the Speaker is empowered to act under the 10th schedule. A useful reference may be made to the recent judgment of the Honorable Supreme Court in the case of Balchandra L. Jarkiholi and others versus B.S. Yediyurappa and others, reported in 2011 7 SCC 1. It is an interesting case which had come up before the Honorable Supreme Court from state of Karnataka and touches upon this aspect. The fact of the said case were 13 MLAs of BJP and 2 other independent MLAs wrote to the Honorable Governor indicating that as MLAs of BJP they had become disillusioned with the functioning of the government headed by a chief minister and also the leader of the legislature party who belonged to their own party. After stating their reasons, they added that they were withdrawing support to the BJP government headed by Mr. B.S. Yediyurappa, but they would support BJP government with any other leader from BJP in its place. On the basis of the said letters, Governor asked the BJP Chief Minister to seek vote of confidence in the Legislative Assembly and also intimated this to the Speaker. On the same day itself, the Chief Minister filed disqualification petitions against his own MLAs, accusing them of voluntarily giving up membership of the political party. Upon issuance of show cause notice, the MLAs filed a reply stating that they did not intend to withdraw support to BJP but had withdrawn support only from the government headed by Shri Yediyurappa and that they would support any BJP government headed by a clean and efficient person. They asserted that their conduct did not fall within the scope of paragraph 21A of the 10th schedule. The Speaker, however, disqualified the MLAs under paragraph 21A of the 10th schedule. The Speaker's decision was challenged before the divisional bench of Karnataka High Court. The division bench, comprising of Honorable Chief Justice and Justice N. Kumar, gave differing judgments. The Honorable Chief Justice rejected all the contentions of the MLAs and dismissed the writ petitions, while Justice N. Kumar, in his separate judgment, differed with the views of the Honorable Chief Justice in regards to interpretation of paragraph 21A of the 10th schedule and set aside the Speaker's order. The matter was then referred to a third judge, who in turn concurred with the judgment of the Honorable Chief Justice. Thus, by a majority, it was held that Speaker had rightly disqualified BJP MLAs. The order of the Speaker and the judgment of the High Court was challenged before the Honorable Supreme Court. In its judgment, the Honorable Supreme Court extensively referred to with approval the observations made by the dissenting judge of the Karnataka High Court, Justice N. Kumar. I am in complete agreement with this view and am bound by it. I reproduce the said paragraph which are relevant for the present purpose. Justice N. Kumar, who along with the Chief Justice heard writ petitions filed by the appellant herein, in his separate judgment differed with the views expressed by the Chief Justice in regards to the interpretation of paragraph 21A of the 10th schedule of the Constitution. The learned judge went on to further hold that when a member of a house expressed his no confidence in the leader of a legislative party, and if he happened to be the Chief Minister who is heading the Council of Ministers and had written to the Governor in that regard, such act by itself would not amount to an act of floor crossing. Similarly, if the Governor, after taking note of the expression of no confidence, was satisfied that the Chief Minister had lost majority support in the House, he could call upon the Chief Minister to prove his majority on the floor of the House. It was further observed that if the Chief Minister, on such request, failed to establish that he enjoyed the support of the majority of the members, the ministry would fall. But such an act of the member of the House would not constitute defection under 10th schedule. By such an act, the political party which had formed the government would not lose its right to form a government again. On the other hand, what is disturbed by such such an act is the government of the political party with a particular leader in whom the members of the House belonging to the same political party have no confidence. But this would not mean that the member of the political party to which the Chief Minister belonged had given up his membership to the political party. Having dealt with the various decisions referred to here and above, the learned judge came to the conclusion that it was clear that an act of no confidence in the, in the leader of the legislative party does not amount to his voluntarily giving up membership of the political party. Similarly, his act of expressing no confidence in the government formed by the party with a particular leader as the chief minister would not also amount